Good afternoon, everyone. Good morning to those of you on the West Coast. Welcome to our program today entitled Nonprofit Chapters and Affiliates, Finding Structures and Relationships that Address Your Challenges and Work Well for Everyone. My name is Jeff Tenenbaum, Chair of the Nonprofit Practice here at the Venable Law Firm. And as many of you know, this program is part of the monthly series that we do every month for the last almost 6 years now on a wide variety of different nonprofit legal topics. Today's program is one that I'm particularly interested in and excited about. Nonprofit chapter and affiliate relationships is in our nonprofit practice here at Venable. It's certainly one of the major topic areas that we deal with all the time. My colleague here, George Constantine, and who I'll introduce in a minute, and I and everyone else in our group, frankly, deals with these issues virtually every day and have done so for many years for hundreds and hundreds of different nonprofit organizations. There's some really interesting, difficult, challenging issues in this area from a legal perspective, from a tax perspective, and from many other non-legal and tax perspectives. And in this area, it's really impossible to separate sometimes the legal and tax issues from the other political and governance and public relations and financial and other considerations that come into play. And we're certainly going to be talking about all of that here today. It's an area where there is no silver bullet. There's no magic formula to what makes the best or the healthiest chapter or affiliate relationship in the nonprofit world. We've seen everything under the sun. We've seen some very successful, healthy relationships. We've absolutely seen the exact opposite. And frankly, a lot of times things go up and down, and they trend over time. But there's no question that there are some best practices that we've seen in the area. And that's really what the focus of today's program is going to be, to try to help your organizations and the organizations that you represent find the relationships and the structures and the way to carry out these relationships in a way that works best, not only for your primary organization, the national or international organization, but for the chapters and affiliates as well. Few housekeeping tips first. For those of you in the Trade and Professional Association community, these programs are eligible for continuing education credit under the CAE certification program. Preview of our upcoming programs. We have 3 scheduled so far for this year. Next month, March 10th, once a year we devote one of our programs to the various compliance and regulatory and other issues that go along with receiving federal money, federal grants, cooperative agreements, and contracts. And that is going to be the focus of our program next month. The program is being co-sponsored by Inside NGO, and we have a terrific panel, including probably the key person on the enforcement side in the Inspector General's office at USAID, a terrific panelist from BDO, and 2 of our own phenomenal lawyers in this area. This is an area, the federal grant and contract compliance area is an area that we do a huge amount of work. It's becoming an ever increasingly complicated area for any of you who receive federal money. You know that very well. And if you do, or if you're planning to or thinking about receiving any kind of federal awards in the future, be sure to come to our program or dial in next month. On April 14th, our program is entitled UBIT, What Your Nonprofit Needs to Know About Sponsorships, Advertising, Royalties, and Cause Marketing. This is an area, again, in which we do extensive amounts of work for hundreds and hundreds of different nonprofits every year. This is not an area where there's been any particular new developments in recent months or years, but it's an area that is as I'm sure virtually all of you know, it's kind of a bread and butter staple issue that all of you deal with. It's an area that has a lot of nuances. It's an area that we've learned kind of a lot of great tricks of the trade over the years. We have 2 of our attorneys who are going to be, and actually one of our attorneys and a general counsel from one of our clients who's going to be speaking to those issues on April 14th. And then in an election year, we couldn't help but focus on some election year legal and regulatory and tax issues for you on May 19th. Our program is entitled Election Year Activity, How Your Nonprofit Can Be Legally Active in the Political World. This is a program that is designed to be of interest to all types of nonprofit tax-exempt organizations, 501c3s, C4s, and C6 organizations. A terrific program I hope you'll be able to participate in. All of our programs are recorded and posted on our nonprofit YouTube channel. You see a link to that at the end of today's PowerPoint presentation. Those of you in the room here have a handout booklet that has copies of the PowerPoint slides along with a couple articles. One of which I just happened to notice in the American Society of Association Executives monthly magazine, Associations Now, just came out like 2 days ago, and I start to read it, and Paul Stalknecht, one of our speakers today, is the first one quoted in the article. So ASAE was kind enough to give us permission to reprint that article. It's a great article. I encourage you to read it along with one that we wrote a few years ago. Those of you on the webinar will receive an email tomorrow. All of you will receive an email tomorrow with a link to the recording of today's program. Feel free to share that with colleagues or others who may benefit from it, and it will also have copies of all of those handout materials along with the PowerPoint slides. In terms of questions today, those of you in the room, we encourage you to ask questions throughout the program. Just do me a favor and wait for the microphone to get to you. Just raise your hand. I'll call on you and someone will bring you a mic so that everyone on the phone can hear your questions. But feel free to ask questions throughout the program. And those of you in the webinar, pose your questions to me at any time using the chat feature, and I will pose them to our speakers. Now, brief introductions of our speakers. Their full bios are in your handout books, and those of you on the web should have received that in the email. But very briefly, to my immediate right is George Constantine. George is a partner in our nonprofit practice and also co-chairs the firm's regulatory practice group, in which our nonprofit group is housed within the firm structure. George and I have worked together for virtually all the time that I've been at Venable. I've been here almost 17 years, and George probably about almost 15 years. We've worked very, very closely together for many years. He's an invaluable part of our nonprofit practice and a fantastic nonprofit lawyer who has extensive experience with these issues, and you're going to learn a lot from George today. And to George's right is Paul Stalknecht. Paul is President and CEO of the Air Conditioning Contractors of America. ACCA has a special place in my heart as they were my first client about 20 years ago. First client I ever started working with, and had the privilege to work with them ever since. Paul's been there for the last 15 years, has done a phenomenal job in leading that trade association to some great places. They have a very dynamic chapter structure that has had its challenges over the years, and Paul has led some very innovative changes in that area, and we thought he'd be a perfect person to speak not only to ACCA's examples and what all of you can learn from that, but to speak to these issues more generally. And so with that, I'm going to turn it over to George to get us started. George.
Thanks. Thanks, Jeff. Good afternoon to everyone. Good morning to those of you on the phone. Is this coming through? Can you hear me okay? Yeah. So Paul and I today, sort of plotted our agenda to talk a little bit with some background, start with a little bit with some background about chapters and affiliates. And when we talk about that, we're talking about a nonprofit organization with geographic chapters, throughout the U.S. or throughout the world, as it might be, and we'll talk about that. I'll also talk a little bit, when I say affiliates, I'm talking about relationships that you might have as a nonprofit with a for-profit subsidiary, a related other nonprofit type of organization that may not be geographic based. So we were trying to hit on both of those and talk on the relationship issues that can come up with both. So after we go over the background, I'll give a little bit of the legal and tax framework, and if you're still awake after that, Paul will give a great sort of case study example of what I like to call a profile and courage for what Paul has gone through with his own organization, and also share some of his experiences just being a seasoned nonprofit executive that he is. And then we'll conclude. Throughout the process, we definitely encourage you to ask any questions you may have. Jeff will be monitoring the questions that come through the webinar, and we'll certainly take the questions here. There will be a mic that we have to circulate, so be patient as that goes through. Just curious, for those of you here in person, how many of you are with organizations that currently have a chapter structure, or work with organizations that currently have a chapter? Right. And how about an organization that has multiple affiliates, not outside of the chapters, but related entities, things like that? Okay, let the record show that a lot with chapters and about half with affiliates. So, and how many are you here for Venable employees here for a free lunch?
They're not raising their hands, but I know there's a few there.
There's one bold person back there. Anyway, so that's good. That's good background to have. So one of the first point we want to sort of talk about is why would an organization have chapters and affiliates? And obviously there's a number of reasons that we would do that. And from a chapter perspective, clearly you get a local base, and that local base helps to perhaps better raise funds, better get membership, and better connect on a local geographic level. My experience in working with nonprofit organizations over the years, chapters are tremendous. I call it a farm system, what they say in baseball terms, a breeding ground for good new talent when you're looking for volunteers. Every nonprofit organization is forever looking for those good and active volunteers, and chapters are often a great place to find them. And then from an affiliate perspective, usually from our perspective, what we see with if you have a for-profit subsidiary or if you have a foundation or some other, maybe a related 501c4 organization if you're a C3, there are legal and tax reasons that you need to do that. If you have a lot of unrelated business activity, you're going to house that in your for-profit subsidiary. Obviously, that's a compelling reason to do that. If you're a 501c3 that wants to get a little more active in the political game or in the lobbying game, you would form a related 501c4 often and do it through that affiliate as well. So, there are sort of good reasons to do that, but I have to say that, and we'll get to it, it's not always the case that, we must have a chapter structure and we must do it this way, or we must have an affiliate because everyone else that we know has a for-profit sub or everyone else we know has a related foundation. We'll talk a little bit about, when it might not be so compelling to do, and what Paul will get to is, when it might be a good idea to break things up a little bit. So.
And I should add, too, that we've seen plenty of other reasons, too, why nonprofits form affiliated entities. I'm not really talking about chapters, but more affiliates. Like George said, they're principally usually driven by legal and tax reasons, liability protection, things that one type of tax-exempt entity can do that another can't. But we also see it sometimes where an entity, will have, say, multiple 501c3 affiliates or multiple 501c4 or C6 affiliates. Sometimes it's to have each one have a different focus, and maybe a different set of volunteer leaders that are driving that focus. Sometimes it's for fundraising reasons. Sometimes you don't want to, show certain information on a Form 990 of one that you might not want to have on another. So there are lots of different reasons, sometimes for federal award reasons. Lots of different compelling legal and non-legal reasons why it can be helpful to set up different affiliates. That being said, I think in our nonprofit practice, our general rule of thumb has always been to counsel clients, don't set up affiliates unless there's a really good reason to. Because as we're going to get into, they are a lot of work from a legal, from a financial, accounting, and other perspectives, from a governance perspective. And to do it right does take a lot of work and headaches. But if you determine that it is worthwhile to do so for any of those reasons, or for instance, say you're a nonprofit and you want to go out and do some kind of a combination with another nonprofit, but they're really not ready to, not now or not ever ready to kind of merge into your organization, you might create some kind of affiliated relationship with them where you have certain control over the governance of the other entity, partially, more fully. That may evolve over time. There's lots of different reasons for doing so, and we're not discouraging you from doing it, but we do encourage our clients to always go in with their eyes wide open.
You got it. Well, good afternoon, everybody. I'm Paul Stalknecht with the Air Conditioning Contractors of America. It's a pleasure to be here with my colleagues in the nonprofit world. I got to make an observation. When Jeff started, he talked about his relationship with my organization for the last 15 years. Venable is a great law firm. We use them super. Jeff's a great attorney. But I did make one obvious observation this morning. When Jeff calls me on those billable hours, he speaks a lot faster at the podium here today than he does on those phone calls. So I did make a note of that, Jeff.
Duly noted, Paul.
But really, when you talk about the evolution of chapters and affiliates, there's no doubt that every nonprofit is different, both in size, type, scope, and culture. But in many ways, they're the same. You have a constituent group out there, a membership group that's outside of the parameters, and many times from a national organization. And certainly it's not the 60s or 70s or 80s in my day, which was the heyday of local organizations. The world has changed. Networking is different. Back then, the only way, especially in my sector of the industry, the members, the contractors could get information is they went to a local meeting and they talked to other contractors. And they found out about local trends, they found about best practices, they shared it by communications, usually over a cocktail or a beer somewhere. Then all of a sudden the world changed with iPads and iPhones, the internet, chat rooms, and communications today are totally different. And the challenge is that few people want to attend local meetings, okay, to learn about networking, to learn about best practices, because it's all sitting here on their phone. So the world is much different today, than it was back in the 80s, which makes us as the association and nonprofit leaders to really take an inward look to where we're going with our chapter structure. Is it working today? Is it not working? I can tell you this, where chapters work, they're phenomenal. It's a great system, but where you have impediments and where they're starting to impact your operation, they become a challenge. And that challenge sometimes is hurdles that you cannot overcome, which we'll talk about a little bit later.
Yeah, I mean, I have to say, I reiterate that from what I've seen with our own client base, that, time and again, the chapter structure that was often very financially lucrative has become more of a money pit for many of our organization clients, because no one's going to those meetings. Those meetings were often a source of revenue and connection, and it's just really dwindled. So we've seen that again and again. A couple other points. All right. Okay. Other reasons that, and Jeff sort of alluded to this in his comments, other reasons that you might be, a little hesitant to go and form a new affiliate or go and, establish a new chapter structure, or, maybe even consider doing away with the current chapter structure, is there's a tremendous amount of compliance that goes along with any new entity that you form, be it a chapter, be it an affiliate of any way, shape, or form. And there's work involved, and we'll talk a little bit about that. I mean, including not just filing the annual Form 990 or Form 1120 if you're a tax-paying entity, but engaging in staff relationships, contracts, managing all the corporate formalities that you have to manage in order to be a separate entity takes time and takes effort, and it adds to risk to the overall enterprise when you have more of these compliance obligations before you and you have to meet them. So oftentimes that's a point that will be a compelling reason to think twice before jumping into a new structure or a new affiliate. Also, again, as Jeff alluded to, there's a lot of organizations that we represent that have formed, for instance, a related foundation. If, say, you're a 501c6 organization, you formed a related foundation, and the goal was, hey, we can raise funds through charitable contributions and really blow it out. But what we found in practice very often with some of our clients is what you end up doing is competing for the same funds. You have sponsors with your 501c6 association. They're sponsoring your events, your activities, and have generously given a lot of money to the organization. And lo and behold, that's the same pot of money that's being sought after from the 501c3 related foundation. And from the sponsor's perspective, from a tax perspective, it doesn't really matter that it's going to a 501c3 or a 501c6, because you're taking a tax deduction for that for reasons other than a charitable contribution deduction. You're almost always taking a tax deduction as a marketing expense. So sometimes, for instance, the formation of a related foundation, while it sounds great at the outset, in practice can, not reach its potential, because we've got, the same sources of money we're going to with two different asks. So it's not always, it's not always as effective as it might seem.
And George, let me just interrupt not to disagree in that it's absolutely true. But at the same time, there sometimes are funding sources that are only available to C3s, like money coming from private foundations, for instance. Even a lot of public charities only want to give money to other C3s, even though technically, in certain cases, they can give to a C6 organization. And certainly, federal, state, and local government grants are generally restricted to 501c3 organizations. And there are other benefits as well, certain property tax exemptions in certain places, sales tax and use tax exemptions in certain places. So there are sometimes, some very valid reasons for having the C3 status. But George's point is a great one, that don't just assume that because it's a C3 you're going to go out and raise charitable contributions and it'll be a big heyday for you.
And I think that's a good point. Obviously, there's a lot of benefits to having that status. From a management perspective, I think it's easy to fall into reaching for the same source of funds that the C6 already has, the sponsors of the events and those sorts of things. if you can get a better focus on those sorts of sources of funds that Jeff just referred to, and there is, oftentimes grants, government grants, private foundation grants, and those sorts of things, if you can get a focus from your foundation affiliate and the leaders of that to go towards that instead of, what's sort of the easier path perhaps, which is the tried and true sponsors of the C6, but really go after that new money, that's a more fruitful endeavor. But I have to say in practice, what you normally see is sponsors getting upset about being asked twice for the same dollars.
Which is also an argument for good coordination and cooperation between the C6 and the C3 in those kind of fundraising and marketing efforts. If you're dealing with the same corporations, the big corporations in your industry, it's important to have kind of a coordinated approach to how you go after them for money.
And other affiliation considerations to make before you dive in for a new entity is, say you're a 501c3 organization that is interested in engaging more in lobbying activity. Oftentimes, as I mentioned at the outset, you'll form a related 501c4, an advocacy organization, and there's ample examples of that around town of groups that do that. But sometimes that may be done without a full grasp of what you can do as a C3. And there are limits to the amount of lobbying you can do as a C3, but it's certainly not prohibited. A 501c3 organization is allowed to engage in a certain amount of lobbying. So that's, to take sort of a fair consideration of to whether to form a 501c4 affiliate as a 501c3 organization, remember that you have some ability to act within your own organization to do that. So those are some of the, I think, consideration points that we always advise before jumping into forming a new entity. Where's the clicker? So next I'm going to talk about, well, we talked a little bit here already, why affiliate. I mean, there are tax reasons that you want to do that. There are obvious fundraising opportunities you may be open to by having an affiliation or a chapter relationship. There's the ability to get to the local level. And we'll talk a lot about managing liability exposure. I mean, the whole idea of a separate affiliate or a separate chapter, if you do it right, is you're at least guarding your organization against the liability of that affiliate or that chapter. And what we'll see as I talk through this, and I won't go over too much to save a good amount of time for Paul, is there's always going to be a tension between the ability, the independence that needs to be given to these related entities in order to benefit from this liability protection, with the control that you need to have to make sure that they're all sort of singing from the same hymn book, that there's a certain level of management of your brand, of your name, your logo, all of the things that you want to control in that relationship that you do.
Yeah, it's a very difficult tension, and it's important not only for liability protection but for protection of tax status. There's countless cases, rulings, about, for instance, C3s and C4s, not having enough separation and therefore jeopardizing the tax-exempt status of the 501c3 organization. But at the same time, I've yet to come across any nonprofit organization that creates some kind of affiliate that doesn't want to exercise some level of control over that. You don't want it to just go its own way, and so it's a constant tension. We counsel clients on this stuff all the time. There are no bright lines. There's no black letter rules on how much control you can and can't have, overlap with staff, officers, directors, committees, all of this kind of stuff. There has to be clearly, and George will talk about this, certain types of financial and tax and accounting separation. But on the operations side and the governance side, there's often a lot of overlap in order to establish that control.
No question. So sort of this slide sort of depicts a continuum of that control and what you can have. We asked for a show of hands at the beginning. How many of those of you that have chapters, of those of you who raise your hands, how many have those separately incorporated in each of their jurisdictions? How many do not? How many would have them as sort of part and parcel of the national? A little bit of both over there. Okay, I'm sorry for the people on the phone. Most of the people in the audience raised their hands to separately incorporated. A couple indicated they're part of national. What we mean by that is, and we have some clients that do this. It's a difficult road sometimes, but when you're fully integrated, there's no separate legal existence for the chapter or the affiliate. It's all part and parcel of what you do as a national organization. When you file your annual Form 990, you count the revenue and expenses of each of those chapters that come through. That's all part of what you report. The the risk that comes about with any activity that happens at the chapter level is your risk as an entity. You understand that and you've taken that on. Now, to do that, that means you need to manage your risk, significantly. For those clients that I have that have gone through this route of having what they call sort of nominally chapters be part of the overall national, is they have a very strong staff oversight function, making clear that no contracts can be signed by anyone except someone at headquarters staff. No events can be had without notice to headquarters staff, and sometimes presence by headquarters staff. You've got to manage that activity. There are people out there doing things in your name as an organization, and you have no ability to point to some separate corporate shield and say, no, that's not us, that's them. No, they are you. They're part and parcel of the overall enterprise, and so the legal risks and the tax risks that go along with that are something that you need to manage. And obviously another point that's important with a fully integrated structure is, be sure that your insurer knows precisely what it is that's under your umbrella and what it is that the insurer is covering. Because the last thing you want is a situation where the insurer says, well, we didn't know that you had these activities out here. We thought they were separate, so therefore we're not covering it.
And when you have these when you have chapters that are not separate legal entities, they're really just regional, local offices or divisions, of your organization. Then we sometimes, though, in addition, George talked about kind of two options, being fully legally part of your entity, and the other where they're separately incorporated entities. Sometimes we do see a third kind of in-between option, and that's where the chapters, and maybe the national organization too, believe that they are separate legal entities, but some or all of the chapters are not actually incorporated. Now, it may be by accident, where they were incorporated and then they lost their corporate status because they, for instance, failed to file the annual report with the Secretary of State or the Attorney General, whatever office it is in the state of incorporation, or they may have never gotten incorporated, or they just may be set up. There is this legal creature called an unincorporated association that states recognize. And we actually have some clients, I still don't quite understand why they do it, but they actually have affiliates or chapters that they're not incorporated, but they are treated as separate legal entities. It gets a little bit tricky from a separate legal status versus the tax exemption issues and filing issues, Form 990 filing issues and things like that come into play. And we may talk about that a little bit more. But just keep in mind that sometimes, and it's one of the first things that we ask when we start working with a new client that has chapters, we want to see, does the national organization go through those steps to ensure that those chapters indeed are separate legal entities, ideally as incorporated entities. That's certainly the easiest way to establish that.
And so the concern when you do have, when you take the position that you have a separate unincorporated association is, from a liability perspective and from a tax perspective as well, it's easier for the IRS or a court to say, hey, really, they're part of you. They're not separately incorporated. That separate corporate existence helps a lot to establish, drink some, Paul. Helps a lot to establish the position that a court will observe and respect that, yes, you are truly separate, and therefore your liabilities aren't going to be, or the chapter's liabilities aren't going to be assumed by you. So when we talk about these affiliation relationships and the chapter relationships, again and again, from our perspective, from a legal perspective, the biggest thing we're concerned about is what will a court or the IRS say in terms of this relationship? What will they say in terms of whether national is sort of on the hook for the liability, be it tax or legal liability of the related entity? And going through the continuum, we'll also have plenty of, particularly from an affiliate perspective, a parent-subsidiary relationship is very common. So for those of you who have affiliates like a for-profit subsidiary or a related nonprofit, for related nonprofits, how many of you have sort of a relationship where you're the sole member of that related nonprofit, or do you know? I've got a few shows hands there. It might have been a little too technical to ask, but that's often the control mechanism that you have if you have related nonprofit. Is you form say you're 501c6 and you have a 501c3 foundation. You form that foundation in a way that your articles of incorporation say the sole member of this 501c3 foundation will be parent association, and therefore you have the right to name all the members of the board and have other powers. There are other ways to do that too. You can also have within your articles of incorporation and your bylaws other control functions that may not name you as a sole member of the organization, but may give express rights to do so. And there are reasons for that. Again, sticking with the 501c6, 501c3 example, there are reasons for that from a tax perspective, obviously you want the control to the extent you can, because you don't want to lose, have sort of a rogue affiliate go off and then end up competing with you, which we've seen happen. So it's sort of practical management perspective. You want to control your subsidiary always. But from a tax perspective, and I'll get into this a little bit later, in order to have public charity status as a 501c3, you can achieve it in many different ways. One easy way, if you're a subsidiary of another C3 or even a C6 or a C4 or C5 for that matter, you can achieve public charity status as long as your parent is also publicly supported. Public charity status is very important, as you all know, compared to private foundation status, a much better position to be in. So it also helps from a management perspective. If you have a relationship with a related foundation where that foundation is a supporting organization to you for that public charity status, you can point to the IRS rules and say, yes, we need to control you because the IRS says we need to control you in order for you to have this status. And we've unfortunately had more than a few instances where the related foundation has, through its current, whatever its leadership might be, has sought to separate itself from the parent organization. And it seems to happen again and again, by the way. And thankfully, we've been able to point to that relationship in many circumstances to say, before we get one step further, we have to have it this way for you to maintain your public charity status. So.
Only thing I'd add to that is that we're a big believer when it comes to affiliate and subsidiary relationships in kind of a belt and suspenders approach to lock in that essential control. Again, of course, the control can only go up to a certain line without jeopardizing the separate legal and tax status of those entities. But in addition to either having, creating that affiliate as a membership organization with the parent being the sole member, or having that kind of control, ability to appoint and remove directors and officers, et cetera, locked into the corporate documents, the articles of incorporation, and the bylaws of both entities. We also always recommend that there be a contract between the entities. We often refer to it as an affiliation agreement that talks about all of the different ways that those two entities are going to affiliate. And we usually start with the governance control mechanisms and the right to do those sorts of things, to appoint and remove directors and officers, et cetera, whatever kind of overlap there may be in committees and other things like that. But then you also can talk about how the employees of one are going to be leased to either for a fee or donated to the other affiliated entity. You're going to talk about other kind of the financial relationship between them. You're going to include the trademark license. If the affiliate is going to be using the name and or logo of the parent in some way as part of its name or any other intellectual property, you want to have license provisions in there. So it's really important, George has it here in this slide, contractual affiliation, that you want to have a written agreement between your nonprofit and any and all subsidiaries and affiliates that you may have. And one footnote on the word subsidiary. Technically, a subsidiary only exists where there's ownership. In the nonprofit world, a nonprofit corporation by definition has no stock. So a nonprofit cannot be owned by anyone else. We hear this bandied, this kind of terminology bandied about a lot. The only subsidiary relationship there can be in the nonprofit world is where the nonprofit owns a for-profit subsidiary, which is not uncommon. In fact, it's very common, increasingly common. Nonprofits can own as many for-profit subsidiaries as you want that can engage in any activities that they want to without restriction. Of course, they're going to pay tax and net income, but then the after-tax profits can be paid back to the nonprofit parent in the form of dividends, which are tax-free on an unlimited basis. That is a subsidiary relationship. Any other type of nonprofit to nonprofit relationship is what we usually refer to as a controlled affiliate. So just for terminology's sake, I wanted to make that clear.
Yeah. Thanks, Jeff. So getting to the specifics of where the legal risk can come about when there is an affiliate or chapter relationship, even when you have separate incorporation, you may have heard the term piercing the corporate veil, which is a term sort of developed through common law over years and years. Each state has its own development of this law. The idea is that even though you have a separate corporate status, we, the court, are going to look beyond that separate corporate status and say you really are one and the same anyway. You're fully controlled by your parent. You have no sort of individual control or effectively, you are a mere instrumentality of the parent organization. So regardless of the fact that you went and filed a corporate documents with your organization and that you've stayed up to date on your corporate filings, we're going to look to the overall facts and circumstances and say, doesn't matter. The liabilities of this organization apply to the other organization because you're so closely connected. That doesn't happen very often. Courts are really hesitant to go that far, and the IRS too. There are situations recently where the IRS has, and we'll talk about some of those, so I don't want to overstate, but at least from a legal liability standpoint, the courts are going to look to certain factors, and there's a large number of them. I'll go over some of the high points to see, are you truly separate, or is this really being so controlled that there really is no separate entity? And the most significant amount of case law that has developed on this is on the for-profit side, as you might imagine. So a lot of it has to do with like inadequate capitalization of the subsidiary. You've not given them enough money. You've clearly just set them up to be a tax shelter, for instance, and they don't have any independent business reason or any independent, sort of long-term profit horizon at all. But from a nonprofit perspective, the real important ones to pay attention to are what I call kind of corporate formalities, but separate board meetings, separate board minutes, ideally not a fully overlapping board of directors. These are all factors. Not any one is going to be fatal to the separateness of the organization, but these are all factors the courts have looked at over the years. Very important, separate bank accounts. It sounds obvious, but the cases are littered with examples where there's a sort of a shared bank account between separate entities. The direction or the control of the organization has to come from the board of that corporation. It can't come from the board of even if it's a parent. Sharing of staff and resources is a factor that courts will look to as a reason for potentially piercing the corporate veil. In and of itself, it's never been enough to do that, and I say that because I know that a very traditional and common affiliation relationship that we have in the nonprofit world is some sort of management relationship, some staff relationship. We can't go and rent space for our little, small affiliate. We can let them use our space, and we can give a portion of the time of our staff. Jeff talked about the affiliation agreement. I'm going to talk a little more about the importance of that. It really helps, and in fact is absolutely necessary to have affiliation agreement that details precisely what you're going to be paying for the use of that space, what you're going to be paying for the use of that staff, how you're going to be tracking it. You can do allocations based on, of overhead based on staff time and those sorts of things, but it needs to be, a fair and reasonable allocation. Usually it's based on actual amount spent, employee time and that sort of thing. If there is this substantial involvement or control, along with some of these other factors, then there's a possibility that your affiliate may be viewed as not truly separate from a legal liability standpoint. One point that came up very recently, well, in the scope of development of tax law very recently, I think it was like 4 or 5 years ago, from the IRS was a technical advice memorandum that it came out with regard to a 501c3 organization that had an affiliated C4. 501c3, devoted to public benefit, limited amount of lobbying it can do, absolutely prohibited from engaging political activity, obviously. Well, in this instance, the C4 was a local affiliate, and it was engaging in some political activity, as is permitted under the tax code. But the IRS took issue with the connection between the C4 and the C3 and really focused like a laser on the internet website of the C4. And the way that the C3 sort of structured its website and had its affiliates focused on the website, it kept the frame of the C3 around the pages, if you know what I mean. So you pull up a 501c4 website, it still says 501c3 name and logo at the top. In addition, at the bottom, the copyright notices, the privacy policy and all of that, when you clicked on that, it all went to the C3. This is a website of 501c3 organization. And there are a number of other factors, none of them too significant, and all of them in the totality, I was thinking when reading it, I'm sure there are other organizations that would fit in this bucket. And the IRS ended up attributing the activities of the C4 to the C3 in the technical advice memorandum. Now, the logical, enforcement path that the IRS could take, I'm not sure if it did, would be to then go to the C3 and say, we're going to revoke your tax-exempt status because you engage in political activity. Now, don't see too many revocations for that these days from the IRS, but that's the risk that we're talking about here from a separateness perspective.
Just 2 quick corollary points. And if you're more interested in this first point, attend our May program. When George refers to political activity, he's referring to political campaign activity that's supporting or opposing candidates for public office. That's an activity that's completely banned for 501c3 entities, but is permitted to a certain extent for 501c4 and 501c6 activities. Be sure to distinguish that from lobbying activity, which is lobbying for or against legislation. While the definition doesn't necessarily include this for tax purposes, most people also refer to lobbying as trying to affect administrative actions by the federal executive branch or state executive branches. But be sure to distinguish lobbying from political campaign activity, because as George said earlier, lobbying activity is permitted for 501c3 activities up to a certain point. The other point I wanted to make is that it gets very confusing. We're throwing about all these 501c terms, C3, C4, C6s. It's important to understand when you have entities that have different tax statuses, they're affiliated, a C3 with a C4 affiliate, a C6 with a C3 affiliate, whatever the case may be. The flow of money between them the rules are not the same. So what you have to look at, for instance, if a 501c6 trade or professional association has a C3 foundation, it is permissible for the C6 to pay for and donate the staff time to the C3, to donate the office space, the office services that the C3 has utilized. We always strongly recommend that you track that you account for it, that you treat it as a donation, and all the books and records reflect that. But it is permissible to not get reimbursed if you don't want to get reimbursed for that. Of course, it's certainly permissible to get reimbursed if you're in a position to do it up to fair market value. But going the other way around, it's not permissible for a C3 to make that same sort of donation to a C6 organization. And that's because from a tax-exempt status perspective, what the C6 does not fit within the scope of the C3's tax exemption, although on the flip side, the other way around, it is permissible. And so it's always important to understand that, because and we're not just talking about staff time and office space and officer services, we're talking about anything of value. Money, intellectual property, anything else. If it's going, say, from a C3 to a C6 or C3 to a C4, you have to be sure that you're getting fair market value in return, or that you can otherwise justify that it's in furtherance of the C3's exempt purposes.
Great point. Yeah, we represented some client organizations that have been audited by the IRS with a C3, C6 relationship, and the auditor focused pretty quickly on one of those, on how the C3 was being used by the C6 to support the C6's initiatives. Not a good thing if they're not being compensated for it, doing things like market research studies and the like.
Yeah, and I know the one that you're thinking of where the IRS really kind of drilled down hard on this one, and it's a situation we see all the time where a trade professional association has a related foundation, that is engaged in, and I'm using air quotes here, education and or research. But really, all the education and research is designed to further the industry or the profession that's represented by the association, not really for the public benefit, which is what a C3 is supposed to do, primarily benefit the general public. And the IRS really drilled down on that, and in order to resolve the audit without jeopardizing exempt status, we had to broker the repayment of quite a bit of funds by the C6 to the C3.
We'll continue to be nameless on that, of course. When we talk about the relationships between a national organization and its affiliates and its chapters, a few legal issues also that come into play, and they all will be addressed in affiliation agreement or some sort of chapter charter agreement or something like that. Very important to address all these as comprehensively as possible in that sort of agreement. Intellectual property is really big in this situation, and particularly because you're letting your chapters and your affiliates use your name and your logo, even if it's the ABC organization of Michigan. Your ABC organization name is part of that name, and very often the chapter will have use of the logo and maybe amend it a little bit to include the geographical indicator. Well, that's your intellectual property. If you don't protect it through affiliation agreement, some form of license of your trademark within that agreement, you're at risk, should things go badly and the chapter decide to split, of having this name out there with the organization still using your name. An example of a sort of a good story from the case law is from Villanova University. At some point there was a Villanova group that was a 501c3 affiliate of Villanova University that helped to raise funds with alumni and those sorts of things. A Villanova Alumni Educational Research Fund, I think it was. Well, they got upset. The alumni group got upset when Villanova pulled football from its sporting events in the 90s and started becoming a thorn in the side of Villanova University. And so Villanova University looked at the affiliation agreement it had with this group and said, we hereby disaffiliate with you under the agreement. And so the group went its separate way, but kept Villanova in its name, saying that it had developed rights in the name during the term when it was, under, sort of in the good graces of Villanova as part of an affiliate system. Well, that went to court, and Villanova was successful because the affiliation agreement was very specific as to use of trademark, who owns it, and when you have to stop using it, and when you're disaffiliated, you have to stop using it. So that comes up when it comes up with chapter disputes, and you see those in the court system. It very often comes up in the context of use of name going forward.
On the flip side, we're right now engaged with a nameless client, very, very large, high-profile, well-known professional association that's in a very nasty dispute with an affiliate and a subsidiary of it over the use of their mark, and it's a very frustrating, becoming a very expensive, messy dispute, and frankly, it's a great example of how a lot of these issues, assuming that the parties can agree on the terms at the outset, can be avoided and mitigated down the road with kind of a good, clear license agreement. And like most other agreements, like we always advise our clients, you have to plan for the divorce. You have to treat that agreement as a prenuptial agreement and assume that at some point the parties are not going to be affiliated and that you're going to have to revoke the charter or de-affiliate when the entity is going to go its own way or do whatever. But as a national organization or the parent organization, the primary entity, you need to be sure that that entity cannot continue to use your name or otherwise imply some affiliation with you.
The other point quickly is similar to the trademarks. You want to make sure that you protect your copyright interests and other intellectual property right interests in the affiliation agreement, such as your right to use your books, your publications, your membership lists, those sorts of things, just as Jeff mentioned in terms of planning for what we hope never happens. Another quick point I want to get to is some governance issues that go along with chapters and affiliates, and some of this legal, some of this perhaps more non-legal, and just management. It's really important to remember. We do I'm sure you do it with your boards, fiduciary duty spiel once a year. Some sort of board member orientation. You talk about the duty of loyalty. When it comes to the duty of loyalty, you have a duty to act in the best interest of the corporation. And one thing that's a big part of that's important to mention, particularly if you have a board structure where you have representatives from different regions or from different chapters or different affiliates, when they come in and they wear the board of directors hat for national organization, they have to act in the best interest of national organizations. They're not there to get what they can for the chapter. Their fiduciary responsibility requires them to look out for what's in the best interest of the national organization. And you can tell them that, and hopefully it sinks in. It doesn't always, and it's a difficult sort of subjective thing to judge as to when a director may be really just trying to get money back home to the home chapter. But at a minimum, to start the conversation and start the understanding that, look, when you're here on national board, you're here on nationals business, and you're here representing this organization. Sometimes we'll have, with chapters, I'll very often recommend a process for their board structure that allows for some type of representation from national, or at least some sort of approval mechanism for the members of the board on national. Short of that, it's imperative if you have a chapter relationship where they are separately incorporated to have a written process that details things like term limits and the minimum size of the board and the minimum number of meetings and those sorts of things. It's a lot of control you may think that you're exerting over a separate corporation, but time and again with chapters where we've seen problems is it becomes controlled by a small group of people who may be affiliated with the same company. They take it over, they use it as their marketing tool, they use the chapter solely to sort of promote whatever it is their company is doing, and they may, also with a small board that's has a lot of commonality with it, there are a lot of risks that go along with that. It's much harder to police and monitor the activities of the chapter to make sure that they're consistent with your overall exempt status and with its exempt status as well. So having some rules in place, be it in the affiliation agreement, some organizations I know have separate chapter rules that the affiliation agreement will refer to, term limits, minimum size of board, minimum representation from different aspects of the community, those sorts of things. Real important to have. You could also do that in model bylaws. I've seen that as well.
Yeah, we've dealt with 2 clients in the last year, both associations that had related foundations that basically got hijacked, by a very influential chairman, who basically in both cases kind of made the foundation, his own piggy bank for his own pet projects, flying all over the country, incurring significant expenses, on behalf of the foundation for his own benefit in both instances. And in both instances, we had to help the association kind of wrest control back from and convince the boards of the foundation and do a lot of other very difficult things to kind of wrest control back to the association. But like George is saying, a lot of this can be prevented at the outset by having very strong provisions in your affiliation agreement and your corporate documents.
So your affiliation agreement should also address how membership will work, how dues will work if you're a membership organization, how you will split the contributions that come in if you're a charitable organization soliciting funds. There's a certain tithing that takes place with a chapter, national relationship almost always, and both sides usually say it's unfair to the other. But to have that in writing and followed is to the T as you can really helps to manage some of those disagreements that happen throughout. I know it's difficult with particularly, not every chapter is the same. So, the New York chapter or the California chapter may be very self-sufficient and may, not require very much support from national, but, the Wyoming or the North Dakota chapter may be, very much in need of a little bit more than what the normal split is. And you have to manage that based on what your organization is like. The closer you can get to uniform, the closer you can get to some form of written policy that you're following, you can point to everyone transparently. This is how we do it. This is how we split it. And maybe there is an allowance, like a sliding scale for the smaller versus the larger ones. But you're going to help, sort of manage those problems that happen on the chapter level so often. So not just common membership requirements, but also you should address in the affiliation agreement how to distribute contributions as well. From a chapter perspective, it's very important also to have some sort of minimums in place for the chapters to be of a certain size for them to continue to be a chapter of the organization. The smaller the chapter, the more problems tend to occur and the more difficult it is to manage and the more it becomes a financial sort of black hole for national organizations. So oftentimes for membership organizations, that's a minimum number of members. For other types of organizations, it might be a minimum annual revenue amount. It could be just a requirement to always be in the black. And of course, as we talked about, if there are if you dip below the minimums that are established, a good sort of objective practice for disaffiliating needs to be in place, and that needs to be something that gives national a good amount of control. Again, it needs to be transparent. It needs to be followed. Yes.
It is on. Thank you very much. I'm very much appreciating all the comments. Related to but separate from collection arrangements, I'm wondering if you can talk about the range of policies and practices you've seen around approaching funders that might be in common from the national level and from the chapter level.
I've seen and heard it addressed pretty often. I'm not sure that there's anything that comes to my mind as a successful approach. Like, okay, you hit these sponsors, during this time, or these are off limits during that time. I just don't know of any examples. Maybe some others in the audience or Paul has, got some thoughts on that.
No, I mean, as independent chapters, they've got a right to conduct business as they see fit. So if you put in those parameters, you're putting in a very aggressive governance on them, and which probably going to be rejected. There's going to be a lot of animosity out in the chapter level about Big Brother trying to control us, and now they're trying to squeeze us, allowing us not to go some people. The way we operated was just give everybody the freedom to do as they wanted to do as an independent corporation. We would not like them telling us what to do in terms of who to go after for sponsors, nor would they appreciate us telling them that they could or couldn't go after a particular sponsor. So I think the more you're open and the safer you are in terms of any issues, especially as you move down the road, as we did, which you'll hear very shortly.
I don't disagree with Paul at all, but I would say, like George said at the outset, every set of chapter relationships is different. And depending on when, I mean, one thing we've seen is that when you try to place limits and controls on existing chapters that have been around for a long time, it's a hell of a lot harder than when you do it at the outset. So if you're, say, a national nonprofit organization and you're establishing chapters for the first time, it's going to be a lot easier to write into place those sort of rules and restrictions, even on things like fundraising and sponsorships and things like that, advertising, to say, a chapter can't go to a national company without coming to us first and getting permission, or doing it on a joint basis, or whatever the case may be. But you try to throw those restrictions down to a long existing chapter, and you're going to find yourself in a heated battle. But there is no one-size-fits-all, but it's a great question.
So one last point on this that again has come up, unfortunately, pretty regularly in our practice is one of the reasons I said have a good set of policies in place for how your chapter's boards are going to be managed, and have some minimum number of directors and good oversight is we've seen two or three in the last year examples of embezzlement at the chapter level, because power is so consolidated with one person with one bank card who maybe the other person who's supposed to have the internal controls is not looking over the books and those sorts of things. So it's fine for a national to say, for you to be a qualified chapter of our organization, these are the minimum internal controls you must have in place. And I'll be real quick here. I want to get over to Paul. But one thing that I'll just mention as an option is if you have a chapter structure in your tax-exempt national organization, if you don't have it, you have the ability to seek and obtain a group exemption, which means every chapter doesn't have to come in and file its own Form 1023 or its own Form 1024. The IRS looks at the national and the structure and says, do you have the controls in place? Do you have sort of a good process in place to make sure that your chapters are following what you say they're required to follow? And the IRS will sort of let you vouch for them, and that doesn't mean they don't have to file a Form 990 every year. They still have to have a Form 990 requirement. There's a group 990 option as well, so they could actually file information with National, and National would file a separate group Form 990. I have to say that I don't see that too often. But they're still recognized as exempt, but through your group exemption process. It's a long process. The IRS has grappled with it, and they've threatened to change the process, although I'm not sure that's going to happen. But suffice to say, now I can answer questions on it later, but it's an option that's available. What it gives you as national is another, so remember I was saying, as a supporting organization relationship, you have sort of a mandate from the IRS to have a certain level of control over the supporting organization. Similarly, from a group exemption standpoint, you're mandated by the IRS to have a certain level of control over your group exemption subordinates. They're even called subordinates. You actually, that's a good excuse when Chapter A says you're being too heavy-handed. You can point to the group exemption requirements and say we're actually obligated to do that. So.
Yeah, but it is there's a question here. It is a tremendous benefit, particularly for smaller chapters, to be able to have them covered under the group exemption. You can add and delete chapters of subordinates to that group exemption every year. There is an annual filing the requirement that the national has to do with the IRS to kind of maintain that group exemption. But it's a great process. But like George said, it's really important to stress to those chapters that the group exemption means they don't have to file their own 1023 or 1024 application to get exempt status. But they do have to file that Form 990, whatever form it is, a regular 990, the 990 EZ, or the 990N, with the IRS. If they fail to do it 3 years in a row, they will get their exempt status automatically revoked.
That was just the point I was going to make. The 990N is like 5 questions. It's dirt simple.
Yeah. But it's so important. And when Congress in I think it was the Pension Protection Act of '06 put in that requirement that if you fail to file it 3 years in a row, you get automatically revoked. Forget the number of exempt organizations that got their exempt status revoked, and so many of those were small chapters of national organizations. And so it's really important for the national to drive that home.
The way the revocation list looked, oftentimes it wouldn't identify a chapter name, so it would look like whatever the national name was, as though you were revoked, and that was a bit of that was fun. So we already talked about this slide, really. Jeff raised the issues of transferring funds between C3s and non-C3s and how important it is to get that right. Some of the benefits of having a 501c3 status as opposed to others. And we talked about political campaign activities and lobbying. So I think we can move on to one more slide for me, and I'll finally get over to Paul here. This schematic, all we're trying to sort of portray here, these are all the topic points that need to be included in a good affiliation agreement between national and chapter or between national and affiliate. How are we going to handle the financial resources? Is there some split of dues? Is there some support that's going to happen between national and the affiliate? How are we going to do the IP? Hopefully national's going to be very strong about that. We own everything. We're licensing you the right. When we disaffiliate, your rights go away. Insurance and liability, it's really important to make sure that we have good, protection in place there. I can't emphasize this enough. We've had this happen very recently with one of our clients. Make sure your insurer is well up to date, or at least your broker is well up to date on what you're doing on the chapter level in particular. There was, in this instance, let's just say a misunderstanding between what national thought they had in terms of coverage as it applies to the chapters and what the insurance company said they had.
Yeah, and on that point, generally speaking, the national's various forms of insurance coverage, it's often possible to have those policies cover controlled affiliates, be they for-profit subs and or controlled nonprofit affiliates, if you maintain majority control over the ability to appoint the directors of those entities. You do want to get that spelled out in your policies, but it's generally possible. Whereas for separate legal entities, chapters that are separate legal entities, that's almost never going to be the case unless you negotiate, something extra that you're paying a lot more for. I remember, Paul, back in the day, I don't know if ACC still has it, you went out and purchased a separate kind of group policy that all the chapters for directors and officers liability insurance, I think, that chapters could opt into and pay a small premium and be part of that. It's separate and apart from ACCA's own policy, but one that they could opt into, and that's something that some national associations do as well.
Good point. And so the other points, just real quickly, we talked about the importance of emphasizing how governance will work, making sure that your chapter or an affiliate understands the obligations that come with the tax-exempt status that they have, and make sure that it's you're observant of your own tax-exempt requirements. And then the last point that's most important, I think, is what happens when the relationship sours. And I think Jeff put it very well that contracts like this, it's always during the good times when you enter them, but you've got to prepare for the worst. And a process that's fair enough that the chapters can sort of deal with and understand is fine. But by and large, it's your national organization's trademarks. It's your intellectual property that's at stake. It's your name. It's your brand. So that provision should be very strong and give tremendous sort of power to national to be able to end that relationship in a way that upon divorce there is a clear definition as to who keeps the intellectual property and what happens with the chapter or the affiliate.
George, that was terrific. The only other kind of circle I maybe add to this slide, we should have added it before, is something regarding kind of reporting, regular reporting by the chapters of the national organization of what it's doing, its finances, and some sort of an audit and or inspection provision that gives the national organization the right to kind of follow up if it doesn't like what it sees in reports or it's not getting regular reports, to be able to go out and take a look under the hood and see what's happening. And then finally, we have had several questions on the webinar about how does all this apply when you have international affiliates or international chapters. And this is an area that we do extensive amounts of work. We've also covered these kind of international legal and regulatory issues for nonprofits in a number of prior webinars that we have recorded. Unfortunately, it's beyond the scope of today's program, but just I wanted to point out that while everything we talked about really does still apply, there are a whole layer of additional considerations, legal, tax, regulatory, both U.S.-based and foreign-based, that kind of go along with having foreign affiliates. And so with that, Paul, let's turn it over to you.
Well, thank you. Now you get to hear the days of our lives soap opera that we went through at ACCA on the defederation process. But Jeff was right when he said there's no silver bullet. There's no simple answer to go through this process. There's no book that you can go to. There's no textbook, because we're all different. I can tell you that the process that we did go through was about 5 years in the making, because you had to set the stage with your board. Most boards, most people do not like surprises. Boards do not like to make arbitrary decisions. They like to be strategic. And you have to do that as you're going through this process. And the first thing we did, started about 5 years ago, we started recognizing some systemic problems within the association. And we then related those problems to the board at every board meeting, just talked about it, just kind of give them a heads up about what was going on. And we kept the board focused on the issue, that there was situations out there that were beyond our control, that were putting in some hurdles to the association. And so what we then asked the board to do is to help us solve this, because we knew where this probably could eventually lead to. And needless to say, you want to get everybody, especially your leadership, engaged in the process. So the first thing we did was we found a champion on the board to lead this process. We need somebody that, what I say, gets it, and somebody that had a backbone that could stand up to some of the challenges, and someone that was very, very well respected. So we established a ad hoc committee to study issue, and that was probably about 3 years ago. And you hit the nail on the head when you talked about that we reminded the board members of their fiduciary responsibility, their duty of loyalty. We stressed that at all times, that the issues that we're going to be talking about are very emotional, they are very political, and we need to remind them that they're serving on the board to represent the national organization. They're not there representing the interest of any particular chapter or membership segment. They were there representing the ACCA, Inc. And I think that was very instrumental, and probably was, if I say one thing that you could do, and that's it right there, is remind them about their duty of loyalty to the organization.
And Paul, you recall well, in fact, some of this may have even predated your time there. One of the first discussions I ever had with an association board of directors was with your organization, and one of your, the board has kind of representatives from different chapters that really view themselves as representatives of that geographic region or that state, I think, in your case. And they really were there just really advocating for what was in the best interest of their state and their state chapter, not in the best interest of the entire national organization. And those interests, in that particular case, a lot of times did not align. And I had to give that lecture, which I've given many, many times since then over the years to association boards, about the fact that when you serve on a national board of directors, you represent the entire organization. You have your duty of loyalty mandates that you make decisions that are in the best interest of the whole organization, not just your segment that you represent.
I remember that individual well. But when we formed the ad hoc committee, again, we got the a really good chairperson involved. Then you had to do your staff due diligence, and what we did was presented the facts. We presented the data on the membership trends, where we were going. And here's one thing that we found out: we had about 50 state and/or local chapters around the country. Probably half of our country, our members were in a chapter or state organization territory. The other half we call at large. And we looked at the trends, because what we were noticing in the areas where we had at-large members, where there was no add-on dues, we had a 30% membership growth. Where we had chapters where we had the add-on dues, that same period of time, we had a 20% membership decline. And so there were facts, they're indisputable facts. And so that's what we did with the board and the ad hoc committee. We presented the operational issues that we had in trying to sell the organization. We had, because the chapters can set their own dues level, whatever that may be, so could the state associations, and then you had to add those two on to national dues, because if you were in an area where you had a local chapter or a state organization and you wanted to be a member of ACCA, you had to support them. So it was an add-on tier structure. For the same size contractor around the country, we had 150 different dues formulas. 150 dues formulas for the same size contractor. The contractor with 20 employees in Maine was different than the contractor in St. Louis, and St. Louis was different than Kansas City, and it goes on and on and on. So the impediments that we had in putting together a national marketing program were insurmountable. And again, we make sure the board knew this, knew the impediments that we had structurally or systemically in the organization. The board, on one hand, was coming to us and said, we have to grow to membership, we have to make it easier for people to join. And we said we can't, because we cannot put together a national marketing campaign or take monthly credit cards, because we had no idea what the dues level was in that particular area, because it fluctuated so much. We also then made sure that they knew about all the dirty linens of the chapter actions and inactions, and how it was severely impacting our brand name, the ACCA brand names. We had embezzlement issues. We had gross mismanagement issues. We had legal issues that cropped up. And the one I'll never forget is when I was in my office one day, and the front desk tells me that there's a sheriff wants to see me. I'm thinking to myself, whoa, what did I do last night? But what he was serving me was papers to seize the assets of ACCA because of a default judgment of one of our independent state organizations that just ignored a court order. So they got a judgment against that state organization, and they thought it was us. And we explained to them that no, it wasn't us. We have a general counsel in staff as well. But we ran into that, and then we were seeing that our name was being tarnished out in the field by actions that the chapters did or the state organizations, and we had absolutely no control over what they were doing as independent corporations. And so we made sure that the board knew of all of these issues that we had. And again, I talked about that. As I said, that we moved to a one-member concept in 2001. So if you were a chapter in your area or state, you had to join it. It was tiered up. We conducted the dues billing at national. In other words, we assumed the responsibility to do all the dues billings, and then we would send it back to the chapters. It started out as a monthly basis, then we moved it to 2 weeks, and then we just went with automatic transfer. So they got their money very, very rapidly and very quick, because we did not want to impact their cash flow, nor did we ever want to be accused at the national level of playing with their funds. So we were very diligent in making sure that there was absolute integrity in the dues billing process. But again, we had to find out, what did you want to charge for that dues? For example, you might have had a contractor that his dues were $1,500 a year combined. Well, of that, it may have been national was only $300, and the other components, had their add-ons, and it was all over the lot. We also found out that by doing that, by doing their billing and having that mandatory membership requirement, we enable some very poor chapters to exist. Because to be a member of ACCA, what people wanted to join, if there was a local chapter, they had to join. But they saw no value in it, did not want to join, and frankly told us, many people, that they weren't joining ACCA because they refused to have any money go to a local chapter that did nothing other than some social event once a year. So we're just noticing a tremendous amount of issues. So when we did that ad hoc committee, which I call round one, we had a cross-section of the association constituency involved. So we then brought in some chapter executives, chapter leaders. We presented the facts to them. We presented them the membership trends, the impediments that we had, and we let the ad hoc committee draw its own conclusions. And they recognized that there was a complex dues formula. They recognized the inability to market nationally. They recognized our brand name was being tarnished. We recognized that we had no control over the chapter finances, dues, or operations, and we were extremely weak at state advocacy. In fact, as an example, we had one state where we had a chapter, and there was a bill introduced in the state legislature, went through the legislature, signed by the governor to license the industry, and our state chapter didn't even know about it. And needless to say, after the fact, contractors, when they found out that they had to apply for and take tests to get state licensing for business they've been in for 20 years, they were not too happy. And who did they blame? They blamed ACCA, even though we had nothing to do with state advocacy. So we were, again, our brand name was being tarnished by inactions, and the structure enabled some very, very poor and weak chapters to exist. So the ad hoc committee came back to the board, and they acknowledged the structural impediments, and basically the only thing that they could do was recommend a new affiliation agreement be implemented. And that affiliation agreement had some requirements on them. They had to submit their 990s because half of them we found out did not. They had to submit periodic financials because we found out that some of them never even reviewed their financials among the board. Just a whole bunch of issues. But we put that in a new affiliation agreement. But the one thing that they could not figure out how to address and didn't have the courage to do was to figure out what do we do with this complex dues situation. It was kind of like the elephant in the room that everybody ignored. And so that's what they did. They ignored it at that time. And so the board agreed to the new affiliation agreement, which I called a Band-Aid approach to this situation. They kind of took the low-hanging fruit and just did some stuff with it and did not really address the serious issue that we had. But the staff continued every meeting to remind the board of the same problems that we had. And then it was about a year and a half ago where I just went to the board and just said, I can't do anything more. We've got these serious problems. You know about it. You've had an ad hoc committee working on it. You went to the new affiliation agreement. You have got to do two things: fix the federation and fix the dues. Let's kind of just laid it out there for the board. Well, then the board appoints a special committee to handle the issue. So right after that, I had gone to a seminar. I think it might have been an ASE seminar, and they had a speaker there who was a corporate turnaround art expert. And he came out with 4 basic principles, and I just listened to him, and I just said, wow, that's exactly what we're doing. And these were the cornerstone. The first thing he said was, in any organization, be it corporate, association, you have to face reality. A problem exists. You've got to face it. It's not going to go away until you address it. Number 2, you have to determine the relevance of an organization. You have to define your purpose and the need of an organization from a membership perspective. And then you have to find your North Star, develop a direction and strategies to get the organization where it needs to be. And most importantly, you have to be bold. You have to have the courage to make painful but necessary decisions. And it was at the next board meeting I came back, and I told the board about these 4 basic principles. And they listened. And so what they did is then they put together another special committee, chaired by a highly respected and influential ACCA past chairman. I come from a male-dominated industry. I have had one woman as my chairperson. She was the best chairperson I had. She was tough, strategic, smart, and would not back down. And we went to the chairman at the time and just said we would like her to be chairman of this committee again, because she gets it. She was respected, and did she have a backbone? She was unbelievable. But that time, we narrowed down this special committee. We only had the committee of the ACCA officers, which were 7. We brought in no chapter or state association involvement whatsoever. Our attitude at that time was they had their chance. They heard all the issues. They wouldn't address the issues. We knew it was going to be emotional. We knew it was going to be political, and we had to keep the prejudices out. And we had to make the decisions based on facts and reality. And what was best for ACCA, that duty of loyalty back to the board. And we harped that thing over and over and over. What is best for the ACCA national organization? We had to make the tough and obvious decisions, and they did. And they decided to move back to an open membership where each entity set and collected their own dues. We separated the bundling of the dues. Each entity then had to show its own worth and value. We gave the members then a choice again. If you felt that the National was a good organization and doing what it should do and deserved support, support it. But if you felt that a national organization was not doing what it should be doing, well, don't support it. That's shame on us. And correspondingly, we said the same thing at the local chapter level. If you no longer liked what the chapter was doing, or there was no value there, you don't have to join them. It's not a mandatory requirement. So we separated the two. And at the same time, then we canceled all existing affiliation agreements with our state and local chapters and state affiliates. We then moved to a memorandum of understanding agreement with state organizations only. We did not feel that local chapters should be affiliated with a national organization. We felt that local chapters should be affiliated with a state organization and then let the state organization be affiliated with us at the national level. So we created a new category of relationships called the Affiliated Contractor Organizations. We call them ACOs. And the MOU was just a simple agreement to recognize each other. There is very few mandatory requirements in there. I think we took the word shall out of every single one and we just put the word may in there. And it's fundamentally an agreement that says we will recognize you as that state organization in California. You recognize us as the national organization representing your interest. It's basically that. The main things in there is we can work together to promote membership, a whole lot of series. So there was nothing mandatory about that.
Paul, just to interrupt for 1 second. Borrowing a term from kind of the federal grant and contract world, it is always important, though, in a situation like that, to still have certain key flow-down provisions. So if you're going to affiliate with a state organization, the state affiliates with the local chapters, but the local chapters are still using your name and maybe even your logo as part of their own. You want to require that the state flow down certain of those trademark license provisions and other things like that. And what happens if there's a divorce or separation? They can't continue.
Yeah, we're going to get to that. But so then. That was at our annual conference last March. They made that decision. And so now the question is, you made the board decision, what do you do? How do you announce this? And the board chairman and the board officers just said they're just going to call the chapter executives in a room. They were meeting like 3 hours after our board meeting, brought them in the room, and we announced to them at that board meeting that they were we were disaffiliating. We no longer a federation, and they were out as chapters and state organizations. You can imagine the response back at that meeting in terms of
Are you referring to bullet point 4? Is that what you're referring to?
Well, the thing is, I was smart enough to let my board chairman do this. But and they strategically went over all the reasons why. Reminded them of the trends, the market trends, the membership trends, reminded them that they served on a special committee representation 3 years earlier, and they did not address the number one issue that everybody had the problem with, and it had to be done. And so it was no easy way to do this, and that's probably the thing we got the most criticism for. Just the springing it on them. And I kind of use the analogy is, if you've got an employee that you're going to rift or you're going to get rid of in 3 months, you don't go to them and just say, hey, I just want to let you know that in 6 months you're going to be gone, okay, but here's what I need you to do next week and do this and do that. They're out of there. They're gone. And so there's no right way to do this, no wrong way to do this, but the officer decided that they're going to hit it head on, be bold, not sugarcoat it, and make the announcement. So that was in March, and we gave them then till the end of July to do the transition. And the primary transition we had was to decouple that dues billing, because we were doing the dues billing. So that was how it worked out, and the structure went into effect of August 1st of this year. Got a little delay here. As I said, we had some quirks in the dues billing because the contractors kind of were confused. Now they're getting 2 billings instead of 1. It's probably going to take us a good year to get through the methodology of having a separate dues for national, a separate dues for a local chapter. Licensing of the name has been our biggest hurdle and our biggest struggle. We are trying to be very liberal with that. We're asking them not to use the 4-letter ACCA. They can't use our logo anymore. But we're trying to be liberal and letting them continue with some fashion of the name under a licensing agreement. And we are not charging for the licensing agreement because it doesn't make any sense to create more enemies or more animosities or make them really struggle. So we're working through that. That's kind of been the hardest issue we've had. We have now MOUs. Before we only had like 8 or 9 state organizations, and now we have 15. Simply because there were some state contractor groups out there that did not come along in 2001 with the new mandatory requirement that they had to support at all levels, so they separated from ACCA. Well, they've come back in the fold, and we're getting very much stronger with that. Our new membership growth in August of this year was 40% higher than it was of the same corresponding August of in 2015. And each month now we have exceeded our membership growth in double-digit numbers since we moved to defederation, simply because we're having contractors saying, I love National, I love what you're doing, I never wanted to join because of that, the bullet to my head, the gun to my head to give money to a local chapter, and they're joining us. And correspondingly, some of our chapters have strengthened, simply because now they had to prove themselves. They had to bring value back to the organization, and they have grown because you may have had a contractor in this area for some reason or another, did not like National, didn't want to join because they had to support us. Now they can just do it locally. We've had a lot of chapters close, and they frankly should have closed, simply because there was no value there. It allowed us then to put together national marketing campaigns where we're just selling it for one price. We have a monthly credit card payment. We can do that now. We couldn't do that before. And it's worked for us. It may not work for everybody. I'm not saying it was easy, but you can't spring this on. It's something you've got to do over a few years period of time. Get your board involved, get them engaged, give them the facts. They're business people for the most part, as we represent. So it's kind of a little bit easier. They understood business. And what we kept telling them is look at this as though you owned the association. If you owned this association and you had all of these independent business franchises out there, and with the problems we just laid out, what would you do? And almost to a person, they came back and said, well, I'd shut down that operation. I'd shut down this operation. So it's just a matter of keeping them engaged and talking to them through the process.
Paul, that was terrific. Thank you very much, and congratulations to you on what an amazing turnaround that you've orchestrated there. You know, between your case study here today and a few months ago, we had another client, Laura Lott, the CEO of the American Alliance of Museums, talk about how their case study and how they blew up their whole membership model and have had enormous success in membership growth, and they kind of blew up, turned to more of a fee-for-service model. But both cases, I think both of which have been profiled by ASAE's magazine, are brilliant case studies about how it sometimes takes some really bold leadership by the staff, particularly by the CEO, to effectuate some major changes like this. But if you have the courage and you do it right, and there's a lot of lessons to be learned from this, you can really have a dramatic turnaround for your association. Thank you very much for participating, George. Thanks for a great job. Thanks to all of you for coming, and we hope to see you back here next month. Thank you very much.